Oh, thank you very much. And you know, before I get, because I think we really need to go through the process, because I think for the public, when a lot of these things are politicized, very, very difficult to separate facts from fiction and propaganda and all of those kinds of things. But it's very important that, you know, because of what is at stake, at the end, even the politicians will say, you know, everybody knows when you are in public office, if you have to be held accountable, you need to present yourself to be held accountable. But this is not new.
He may be a politically exposed person.
Exactly.
In public office.
Oh, sure. Yeah. I mean, politically, either through a transaction or whatever. But this post-regime accountability process is not new. You can go back to the 2000s with Quality Grain, you know, Victor Salome and the rest. 2009 to the Ghana 50 prosecutions. Almost every 8 years, we go through this process. And actually, in a weird way, it is probably the only successful way in which we have held politically exposed persons accountable in this Fourth Republic, right? If we're talking about, you know, even just recently, Sednam Tamaklo, whatever, you can go the list, Atuforcing, all of those people. Now, the issue with what's it called, Wontumi's case is, so there's a Rambo-style arrest issue and then the bail conditions. So the Rambo-style issue, I think a lot of people have condemned, from the the governor of the Bank of Ghana, Kedoforiata, even recently the Kumi gentleman and so on. So I think most people have made the point that for some of these things, there's no need to go in with the kind of force. But when they were trying to arrest, or at least, yes, arrest Wontumi, when apparently they invited him and he had not responded in Kumasi, I am sure any law enforcement agency would have said, if you are going to go and effect an arrest of Wontumi in Kumasi, you definitely cannot go with just a few armed officers, because of what Wontumi represents in Kumasi as chairman. I mean, I've seen him, you know, follow. He has all kinds of following, and we've even seen what has happened subsequently. So anybody that is making a security assessment would have gone. But even in the Kumasi one, some people were saying 20 years, but it was obviously less than that. So even in that particular circumstance, I would say if they went in with armed police and so on, I wouldn't be surprised, because a crowd might even gather there and all of that. The contention around the CID, I don't think the issue around the CID invitation, coming to CID, the charges that have been preferred, I don't think anybody is disputing. I have not heard any complaints about that.
That's right.
So I think we need to put that on the side, right? The Akonta mining matter, and I agree that this has been on the table for long. We've been debating it and discussing it. So the charges and all of that, it's not new. The issue is the Iyoko arrest, and remember, Iyoko has not preferred any charges. Iyoko has only is investigating, and we got in from the AG that they are investigating organized crime, fraud, and money laundering, and all of that. The arrest, again, the concern is that it was made Rambo style. I think by the time Wontumi left CID, and I don't know those who were there who could probably, but at least he still had following, right? So if you were Yoko and you needed to arrest him, how were you going to do it? Were you going to let him go back to and then invite him? I mean, these are law enforcement tactics that are used all the time. So I don't have a problem with whether the person is invited or is arrested. in both cases, there are procedures, legal procedures to follow. If you arrest, you give the person, they have access to their lawyer, all of those things. And it doesn't appear that that was a problem with the Yoko matter. It only became a problem when the bail condition issue was raised. And as we have discussed it all here, there are so many things that go into determining what is bail, the bail value and all of that. And it looks like the kinds of things
But it must be said that even before the bail was set, they stormed the Iyoko premises.
Yes, I know. Because
they almost spent a whole night there.
Yeah. And that was bound to happen. We've seen it in previous time. As I said, this is a typical, after every 8 years, when because particularly when people that are officers of the party are arrested, you get a different kind of mobilization that goes on. Often, like appointees and so on don't normally get that. But officers of the party, you will get that. So people like, they have arrested Wontumi, chairman, regional chairman of the party in Ashanti, and people are mobilizing there. But at that point, there wasn't really, for me, an issue. The bill that was set, which we have gone over, we know that others, they are even, so it's not unreasonable for a 50 million bill to be set, and depending on what is being investigated. But the question was, why didn't the lawyers of Wontumi go to court to vary it? Because that is what the legal procedure is, right? That if the public officer exercises their discretion around bail, that if you want to address it, because often they might negotiate and say, oh no, maybe it's too high, and you get. But it looks like they were unwilling to reduce it. So from Tuesday, I think, when he was arrested, they could have gone to court that way. But from what has happened with the Apia Kubi and what Gary Nwaku went to do, it seems like there's a conflict on who exactly is representing Wontumi. And that is what has complicated the matter. So maybe I'm just speculating here, but from Andy Apia Kubi, he was trying to meet the bail conditions. That was the strategy, that they felt confident that they could meet the bail conditions. And he thought that, as at yesterday night, that could have been addressed. Then there's other legal representation, more from the party, who thought that it is outrageous and they want to challenge it. But they waited. So somehow, this conflict internally within the group seemed to have prolonged the process.
A day before this application was filed.
Yes.
That was on Thursday. And the Apia Kubi was speaking to the media, and he was consistent in what he said last night, that they were working on the bail. People were saying it was onerous, it was whatever. You didn't hear him appear to agree. So all his focus was that I want to get my client out. And he was saying they were succeeding, they were getting closer to it.
So so how do you blame Yoko in this?
Exactly.
In this particular instance? Because
why not blame Yoko? Because people have gone there with similar sort of under similar sort of investigations. Well, some of us have been there privately, yes, doing our business with people the money's in front of them is far, far more.
Way more.
And some of them may walk on self-recognizance. Do you feel that they felt a little insulted that they went to arrest him, they couldn't get him? After they arrested him, the party people stormed the place and were issuing all sorts of threats. Do you feel all of these must have informed?
No, so what I'm saying is that, why blame Yoko is that even if Yoko is unreasonable, that's the whole reason why you go to court to ask for the bail condition to be reviewed. And there are so many lawyers that went there that know what needs to be done. So the choice of strategy that somehow an external person is going to order Yoko to reduce, whether from parliament or from, as they say, the president, how does that address the problem, both for Mr. Wontumi himself, but even the adherence to the rule of law. I don't see what the objective is, right? So at that point, I am confused as to what exactly was, and I don't want to say because the party issue is a separate one. There are political capital issues, there are mobilization issues that we have to consider. But it looks like his lawyer was going to try and meet the surety. But somehow they weren't in communication.
So let's deal with this right now. Do you sincerely think? Hold on. Do you sincerely think? No, we are not leaving this subject yet. Of course, we have other guest on, one more person on the Zoom. Do you sincerely think that Iyoko can't, continue with the process, or could not have continued to finish the process last night because of the application that you are seeing on your screens now, filed by Gary Nimaku for variation of the conditions? Do you think that, like Hassan Tampuli suggested earlier, could Iyoko not have gone ahead and say, yes, we have been served with this, but we can go ahead and do whatever we want to do?
I think they could have. I think they could have and gone and said, well, because what was served on them is not an injunction, right? That, stop, you cannot move on this process.
Exactly.
It could have said, well, we would complete, when we go to court, we would just say this, and if the court feels that it still be reviewed, it can still be reviewed. It's basically a documentation process, right? So I'm not sure, and I'm sure when we come back to some of the Chief Justice ones, this whole issue about when you file a court process, people injunct themselves. So
this very point you made, this very point you made, do you now appreciate part of what Hassan Tampuli was saying, which I asked him a question, that was he suggesting or impugning the competence of the lawyer? If you heard the lawyer live on television say that by virtue of the filing of the application to vary the bail terms, it is frustrated his ability to continue.
Yes.
From where you sit, also as a lawyer and as a governance person.
No, but I don't.
Do you think that if Hassan Tampuli was impugning the competence of the lawyer, he was wrong?
That's for impugning the competence that's for. But I don't think. I think there's an interpretation. Particularly among practitioners, it's something I don't believe in. That as soon as you file a process, it means that, and if the process, even a process for injunction, it means that you injunct yourself first before the court actually determines whether or not there should be.
Those have to do with injunctions. This is not an injunction.
But what I'm saying.
So
that
can you be straightforward with me here?
People treat any kind of court process as an order to stop whatever you are doing. And I think that in this case, both the lawyer and Iyoko also agreed that they couldn't do anything until they deal with this process. But as you're saying, I believe that they could have gone ahead.
If Iyoko had told the lawyer that, should the lawyer be agreeing with them and repeating that to the public?
But how can
Shouldn't the lawyer rather be telling the public that Iyoko is doing this wrong by using this application to continue to detain my client? When this application is not an injunction, they can actually go ahead, process it, grant him bail, and then the application will still be heard. Whether it is varied or it is not varied, it doesn't change anything.
Yes, obviously, we are not instructed by Mr. Chukwu Esiako to act on his behalf. It's Mr. Pierre Kubi who is the person. And he's making these decisions based on his years of experience as a lawyer. So he's taking that action. We are here saying, if we were in his position, we would have done differently.
Okay.
But it doesn't necessarily make his right or wrong.
Okay. So, Hassan, I understand you. Just hold on. I'll return to you.